Good afternoon, everyone. Uh, Welcome to DLC's second webinar in a three-part series exploring our work at Bridgewater State Hospital. This session will focus on the care and treatment provided to individuals at Bridgewater State Hospital, as discussed in our most recent public report issued in February 2025. My name is Tatum Pritchard. I'm the Director of Litigation at DLC. I'm a middle-aged white woman with light brown hair, wearing glasses and a blue blazer. I'm joined by my colleagues, Jordan and Ariana. Jordan, would you like to introduce yourself?
Thank you, Tatum. My name is Jordan Goldstein. I'm a disability rights advocate at Disability Law Center and the on-site monitor at Bridgewater State Hospital. I am a white man with short brown hair and a gray sweater with blue stripes. Ariana?
Thank you, Jordan. Hi, my name is Ariana Murray. I'm a staff attorney and fellow here at the Disability Law Center. I am a Black person with dark hair pulled back in a ponytail, and I am wearing a blue shirt with a black cardigan.
Well, we have much to discuss today, so I think we can get right into it. The first slide that appears is a photo of Bridgewater State Hospital's entrance. For those who have not been there, it appears very much as a prison instead of a hospital. So those who enter are under no illusion that they are in, for instance, a Department of Mental Health facility or a private hospital. The photo depicts the front entrance where visitors and staff enter, surrounded by a razor wire fence. And at the right of the photo is the blue Department of Correction Bridgewater State Hospital sign. We did show this photo during the last session. We show it again simply because it's important to orient us, all of us here on this webinar, to the type of facility that we are discussing today.
This is Jordan. I will discuss the presentation roadmap now. We will begin today's webinar with a review of what Bridgewater State Hospital is, the facility, and the population. We will then move on to discuss a review of Disability Law Center's role in monitoring at Bridgewater. I will say for those who were at the last webinar last Tuesday, the overview, these will be similar to what we discussed last time. Then we'll move on to a more in-depth discussion of the legal standards for restraint and seclusion, and then a detailed discussion of restraint, involuntary medication, and seclusion policies and practices at Bridgewater State Hospital, which will make up the bulk of the presentation. And for those who didn't know what to expect coming into today, that conversation is going to include quite a bit of content around descriptions of violence and forced medication. So, please be aware of that. Lastly, we'll discuss the Old Colony Correctional Center Annex Unit issues, which is a sort of satellite of Bridgewater State Hospital within the same correctional complex. We'll discuss that difference more shortly. And then finally, we'll end with questions. So what is Bridgewater State Hospital? Bridgewater State Hospital is a medium security state prison facility run by the Department of Correction. It includes 9 units. That is 4 medium security units, 2 maximum security units, 2 units for new admissions, or an intake unit, in other words, and a medical housing unit for those with medical conditions requiring more serious care. The primary difference between the medium, and maximum security units is the staffing level on those units. They have more security staffing on the maximum security units. And the two Bridgewater Annex units, as discussed earlier, are in the Old Colony Correctional Center, which is a separate state prison facility in the complex in which Bridgewater proper is housed. That is consisting of two units, one that is for intake for state sentenced uh, individuals who are sent there for evaluation, and then they may also end up being committed on the other unit, which is called the residential unit, also housed in the Old Colony Correctional Center. Bridgewater in total takes in around 1,000 admissions per year. And I will also note that on the slide, we have an aerial view of Bridgewater State Hospital, where you can see roughly a dozen 1- and 2-story buildings, mostly brick buildings, that with a yard in the middle surrounded by razor wire. And so that's the complex that houses Bridgewater. It's not your standard single building hospital that goes upwards. The current Bridgewater population is an average census of around 250 patients. I think currently it's around 230. We've seen it as high as 280. We will mostly refer to them as patients today. If you hear one of us refer to the individuals who are detained there as persons served, it's because that is the word that's used by the contracted provider, Recovery Solutions. So that is also a term we occasionally use for ease of communication, but today we'll mostly be using the word patients. Bridgewater is an all-male facility. It is disproportionately Black and brown men and disproportionately low-income individuals at Bridgewater. It is a forensic psychiatric hospital for people who are civilly committed for psychiatric evaluation and treatment. And the patients at Bridgewater may be pretrial detainees who have pending criminal charges. They may be people who are serving House of Correction sentences, and they may be people who are held only on a psychiatric civil commitment order with no open case or justice involvement at the time. And it's very important to note that all of these same groups who are held at Bridgewater may be and are often committed to Department of Mental Health hospitals, both prior to coming to Bridgewater or after Bridgewater. They're quote unquote, stepped down to DMH hospitals. And women are sent to the Worcester Recovery Center. And everyone at Bridgewater is deemed by the court to require strict security as well. But again, that doesn't, those same individuals may later go to a DMH facility. Next slide, please. So in terms of the legal implications of a hospital run by the Department of Corrections, which again, it should be noted that we discussed in the previous webinar that Bridgewater is the only Department of Correction run forensic psychiatric hospital in the country. So this is an aberration in Massachusetts. And in this facility at Bridgewater State Hospital, DOC regulations and policies apply. These are more restrictive. These include daily lock-in or facility count times in people's cells. There are restrictions on property, restrictions on mail, and unlike the Department of Mental Health, the 6 fundamental rights do not apply there. So those include rights around visitors, receiving mail, various things like that that protect human rights. Department of Mental Health regulations, policies, and guidance that protect patients do not apply. In general, that also includes restrictions on restraint and seclusion practices, including involuntary medication. And as we'll discuss further, Bridgewater security staff use tactical gear in facilitating forced medication, which is just something that would be completely unheard of in any DMH facility. Thank you.
Thank you, Jordan. This is Ariana. We want to take a brief moment to just remind folks about what DLC is and what we do. The Disability Law Center is the designated protection and advocacy agency for people with disabilities. Every state and territory has a designated P&A. P&As operate with a mandate and authority under federal law to protect individuals with disabilities from abuse and neglect and to advocate for their rights and interests. We have federal authority to access all settings where people with disabilities live and receive services, which includes prisons and psychiatric hospitals. We also have the authority to investigate abuse and neglect of people with disabilities. DLC has been involved in continuous monitoring and investigation into abuse and neglect at Bridgewater since 2014. Our work involves providing the legislature, other advocacy groups, and the general public a view behind Bridgewater's walls that have spurred significant reforms and provided greater awareness of Bridgewater, its residents, and systemic issues in the Commonwealth's mental health and criminal systems as a whole. We also provide individuals with support and assistance while they're in an anti-therapeutic environment that silences and harms them. So we discussed this a bit in the last webinar, but I'll remind folks that in 2014, DLC was involved in 2 settlement agreements and that focused on surrounding findings of abusive and illegal restraint and seclusion practice. And the settlement agreement led to significant changes and improvements at the facility. DLC served as a monitor for both of these agreements. Changes coming out of those settlement agreements included closure of the intensive treatment unit, which was a solitary confinement unit that Bridgewater had used for many years for seclusion and restraint, and where countless legal violations and human rights abuses had taken place. The Commonwealth also removed all DOC correctional officers from Bridgewater and engaged with a new contracted vendor to provide mental health, medical care, and security services. Our current work, which our fantastic advocate Jordan is most involved in, includes regular on-site visits to Bridgewater, meetings with Bridgewater patients, staff, and administrators, review of medical records, internal data and reports and video footage, investigations into abuse and neglect, annual mold inspections with a mycology expert, on-site visits and meetings with former Bridgewater patients that then go to DMH facilities or county correctional facilities, and in addition, producing 2 annual public reports surrounding Bridgewater. DLC's reports on Bridgewater call attention to issues within the facility and provide our recommendations to the Commonwealth for what would improve and support the well-being of those who are committed to Bridgewater. Based on our findings, we found that only 2 recommendations can protect the rights and health of the current population at Bridgewater and protect the future Bridgewater population. The first recommendation is that the Commonwealth must immediately place all Bridgewater State Hospital operations under the authority of the Department of Mental Health to ensure that current and future patients have access to trauma-informed, person-centered mental health treatment. And the second is that the Commonwealth must urgently construct a modern DMH hospital facility designed to provide all individuals in need of strict security, psychiatric evaluation, and/or treatment in a safe therapeutic environment, thus finally closing Bridgewater.
Thank you, Ariana. This is Jordan. So this slide is setting up the bulk of this presentation now, looking at the legal standards around restraint and seclusion, as well as the practices at Bridgewater. What we found through our monitoring and have found continuously over many years is that Bridgewater, the administrators at Bridgewater and the providers at Bridgewater uh, are clearly not subject to DMH regulations, policy, or oversight that would protect patient rights and safety. And this creates a stark disparity between Bridgewater and DMH facilities. Another difference is that DOC, in its oversight of Bridgewater, fails to comply with applicable state law and standards of care, including in their oversight of the contracted provider recovery solutions. This results in troubling restraint, seclusion, and involuntary medication practices, which we will discuss more moving forward. And finally, Old Colony, the Bridgewater units, annex units at Old Colony Correctional Center also provide inadequate access to programming, treatment, and an intensely anti-therapeutic correctional environment, which, unlike Bridgewater, includes DOC correction officers in the units themselves. And now we will discuss illegal restraint, seclusion, and voluntary medication, beginning with an overview of these interventions and their legal context. Thanks, Tatum.
This is Tatum. Thank you very much. Again, just in terms of setting the stage for the rest of this presentation, we wanted to lay out what we're talking about when we're talking about restraint and seclusion. Restraint and seclusion are interventions of last resort in psychiatric facilities to be used only when less restrictive measures have proven ineffective in addressing emergency circumstances. The intervention should never be used as a means of coercion, punishment, or convenience. And because of the seriousness of these interventions, strict limitations must be put on the use of seclusion and all forms of restraint. Studies have shown that the use of seclusion and restraint can result in psychological harm, physical injuries, and death to both people subjected to those interventions, as well as staff applying these techniques. Injury rates to staff in mental health settings that use seclusion and restraint have been found higher than injuries sustained by workers in high-risk industries. Restraints, for obvious reasons, can be harmful and often re-traumatizing for people, especially individuals who have trauma histories. Beyond the physical risks of injury and death, it's been found by many studies that people who experience seclusion and restraint remain in care longer and are more likely to be readmitted for care. So when you hear about the restraint and seclusion practices in numbers, we really want for everyone participating and frankly anyone who reads DLC's reports to really internalize the severity of even one of these interventions, and then consider the severity of hundreds of these interventions occurring over a 6-month reporting period. Restraint encompasses, under Massachusetts law, the use of physical force, often called a manual hold or a manual restraint, mechanical devices that could be a 4-point restraint bed, which is what they utilize at Bridgewater State Hospital. It could also be what's known as a restraint chair. It includes chemical restraints, meaning medication restraints, and confinement in a place of seclusion. So under Massachusetts General Law 123, Section 21, where it discusses restraint, it means all of those things. Restraint of a person under the law in Massachusetts may only be used in cases of emergency. Now, the law sets out what it means by emergency, as stated in the slide, such as the occurrence of or serious threat of extreme violence, personal injury, or attempted suicide. So the bar is meant to be incredibly high. Why? Because of the reasons we just discussed, the severity of the intervention and the risk of harm to those involved. For chemical restraint in particular, in addition to requiring emergency circumstances, there must be a determination that the chemical restraint is the least restrictive, most appropriate alternative available. This means that in the continuum of types of restraint interventions, chemical restraint is meant to be the most severe. It means that the other forms of restraint should have been exhausted in order to show that it's the least restrictive, most appropriate alternative available, except in rare cases where circumstances would indicate that regardless of the failure to utilize effectively those other interventions, it remains the least restrictive, most appropriate alternative. And under the Massachusetts restraint law, while the Department of Mental Health Commissioner has a responsibility to review and sign all restraint and seclusion documentation for DMH hospitals, and to review that data from other hospitals, it is the Department of Corrections Commissioner who reviews and signs restraint and seclusion documentation for Bridgewater. Another cause for concern that the correctional agency, rather than our state mental health agency, reviews and approves of these uses of restraint and seclusion. In practice, it has shown through DLC's review of documentation that the safeguard that the law intended by having commissioner review is not served at Bridgewater because the review is done by the Department of Correction Commissioner rather than a mental health authority. There are three types of involuntary medication, meaning not every forced medication is a chemical or medication restraint. There are three different ways in which people can be forced medicated in our state. The first is per what's known as a court-ordered Rogers guardianship or a substituted judgment decision. This requires under Chapter 123, Section 8B, that a hospital provider, in this case Bridgewater, file a petition for court approval of a treatment plan, a court-ordered treatment plan. The court must find, using a substituted judgment standard, that the individual would accept the medication if they were competent to do so, and then the court must review and approve that medication treatment plan. The second legal type of involuntary medication in Massachusetts is the chemical restraint. As discussed, under Massachusetts restraint law and under the state's police power, it may be used to prevent an imminent threat of harm to oneself or others when there's a clinical determination that no less intrusive alternatives to forced antipsychotic drugs is available, and that the statutory and regulatory conditions for the use of chemical restraint are to be followed. So, in addition to being required under the restraint law, these limitations are recognized in case law from our Supreme Judicial Court of Massachusetts. The third type of legal involuntary medication is to prevent irreversible deterioration of serious mental illness. Now, this was originally a creation of the language of the Supreme Judicial Court in cases. The key cases that pertain to these issues are Rogers through the Commonwealth Commissioner of the Department of Correction, and in regards to guardianship of Roe. In In these cases, they discuss all three types, but create the third category, particularly in the Rogers decision. The third type is an exercise of the state's parens patriae power to administer medication involuntarily, essentially for the person's own good. It's limited to circumstances, rare circumstances, to prevent the immediate, substantial, and irreversible deterioration of a serious mental illness in cases in which even the smallest of avoidable delays would be intolerable. Now, if you read the decision in which this language appears, the Rogers decision, you will see that the court intended this to be an incredibly limited exception because, of course, the other two forms of legal involuntary medication exist. The Rogers guardianship and also chemical restraint to address immediate emergency situations where there's a risk to health. Where there's a safety risk. So it's, as we discuss this going forward, please keep in mind these limited categories where there are obligations on the providers to justify and substantiate why these interventions are appropriate. Unfortunately, what we find, as you'll hear, is that the providers at Bridgewater State Hospital do not confine themselves to the strict limitations of these three categories of involuntary medication. In 2024, there were significant updates to Bridgewater's restraint, seclusion, and involuntary medication policies. Following years of DLC advocacy and input on policy language directly with the provider and the Department of Correction, as well as in our public reports, Bridgewater State Hospital, at the direction of the Department of Correction, updated its policies such that they are now largely compliant with Massachusetts law. There are 2 stars next to the word compliant in this slide because there are certain exclusions that had to be made because Bridgewater State Hospital is a Department of Correction facility. The DOC stated that the definition of seclusion must exclude time that patients spend locked in their cells at night during facility quote-unquote inmate counts and during facility and unit emergencies where patients are locked down related to happenings in their unit or in other parts of the facility. So aside from that issue with the seclusion definition, there were incredible changes to the policies that brought the definitions and usage laid out in the policies of involuntary medication and restraint into compliance with the law. The major changes included eliminating an illegal category of involuntary medication that Bridgewater had been using quite widely for a number of years, called emergency treatment orders. These treatment orders, as they called them, were essentially medication restraints that Bridgewater providers said were required for treatment. Now, as we just discussed, there is no such category. There is either a restraint, which is necessary to address emergency circumstances, such as the occurrence of or serious threat of extreme violence, personal injury, or attempted suicide. And then there is involuntary medication to prevent irreversible deterioration of a serious mental illness that is immediate, substantial, and when in circumstances when even the smallest of avoidable delays would be intolerable. The emergency treatment orders was neither of those things. It was essentially if the providers believed that medication restraint or involuntary medication would be helpful or necessary from their perspective for the person's treatment, they would order it, and the person, as discussed earlier, would be subjected to an involuntary medication, either through an oral medication or an intramuscular injection administered by a nurse along with a team of security staff wearing riot gear. Other changes included updated definitions to all forms of involuntary medication. And other important language changes that meant to improve staff understanding and compliance with Massachusetts law and to mirror the requirements as much as possible of Department of Mental Health regulations. Though these policy changes took effect in June of 2024, many staff appear to ignore or be unaware of what current policy dictates.
Thank you, Tatum. This is Ariana. Although, as Tatum said, Bridgewater implemented these new policies on medication restraint, and they have been in effect since June of last year, DLC has been alarmed by how these new policies have been implemented and applied by Bridgewater staff on the ground. DLC continues to review medical records, restraint forms, and security footage from Bridgewater. Although the new policy narrowed the scope of circumstances where restraint was permissible in keeping with state restraint law, we have found through review that staff continue to subject patients to involuntary emergency medication absent the requisite emergency circumstances. In addition, despite the changes to restraint policy, medication restraints have continued to rise in each reporting period. We're going to go into greater detail on issues with policy implementation shortly, and we'll come back to the increase in restraints during the reporting period a little bit later in this presentation. But I'll point out now that medication restraint administrations went up by 25% from our last reporting period. So DLC has made several observations through reviewing records and in speaking to staff that indicate a lack of understanding of the new policy or simple disregard for the updated language in the policy. Emergency treatment orders, or ETOs, were removed from the current policy and are an illegal category of involuntary medication, as we discussed earlier. But patient medical records and daily 24-hour nursing reports that are sent to Bridgewater clinical staff and executive leadership, and these 24-hour reports are also sent to DLC, still frequently mention ETOs, while the term medication restraint is rarely seen in those records. DLC notified the medical executive director and Bridgewater administrators directly about our concerns with the continued use of ETOs on 2 separate occasions. Administrators assured DLC that they would address the issue directly with nursing staff and psychiatric providers, but we've found thus far that the problem of referencing ETOs continues. From what we've observed, it seems that some Bridgewater providers may not be aware of the policy updates or do not understand the difference between the prior policy, which allowed for illegal ETOs, and the new policy, which does not. But it's worth pointing out that some Bridgewater psychiatrists appear to be aware of the updated policy but still disregard it, as they disagree with the law's restricting of their ability to force medicate patients as they see fit. During this reporting period, Jordan interviewed 8 direct care mental health staff about the new policy. Staff interviewed were responsible for a number of things at Bridgewater, including reporting significant changes in a patient's behavior and presentation to a psychiatrist ordering medication restraints, explaining medication orders, reporting to clinicians if a medication restraint is no longer appropriate, and in some cases, administering forced medication. Contrary to what the new policy would dictate, each staff member said that ETOs were still used at Bridgewater. 5 staff members said that they had never heard of medication restraints, and the 3 that had heard of them all said that they were the same as ETOs. These observations are deeply concerning to DLC in terms of the training and oversight of Bridgewater's clinical staff and inevitably the care that Bridgewater patients receive as a result. And with that, I'm going to pass it off to Jordan to go over some additional issues with medication restraint practices.
Thank you, Ariana. This is Jordan. So the Bridgewater medication restraint order form, which is essentially available to all providers at Bridgewater or like psychiatrists or psychiatric nurse practitioners who feel it's necessary to order a medication restraint. This form has been in use actually since September of 2023, so roughly 9 months before the new policy went into effect in July 2024. This was a policy that struck ETOs from the language, the illegal medication we've been discussing, illegal forced medication. And this form, the Bridgewater medication restraint form, replaced that earlier ETO form. So we had some hope that it would reflect Massachusetts law, and when the new policy came into place in July 2024, that it would reflect that new compliant policy. Unfortunately, the form allows for continuing application of medication restraint in violation of a law, even since the new policy came into effect. So in the following slides, we'll outline some of our concerns with this form, which we have actually talked about in the last 2 reports, and continue to advocate for change at Bridgewater about. And while we'll go through this basically section by section, and I just want to point out that this may seem like a minute point about documentation, but it's really important to remember that this documentation is about how and for what reasons or lack of reason Department of Corrections allows its contracted provider to medicate patients against their will, and the lack of a paper trail that they're able to leave, that they leave behind, basically. So with each section, we'll point out basically the ways in which it flies in the face of the state law, and hopefully, this will make some sense here. Next slide, please. So our concern number 1 deals with a section in which providers have to indicate the quote unquote type of emergency on the form when they're ordering the restraint. The options that they're provided are potential harm to self, actual harm to self, potential harm to others, and actual harm to others. And now, potential harm, according to the Massachusetts legal standard, does not justify medication restraint. Remember, it's an emergency such as an extreme threat of serious violence, suicide attempt, or personal injury. So it basically is a very lax standard that's out of step with the policy and the law on these forms. And what's worse, providers often indicate only potential harm to self or others to justify restraining a patient. So there's no actual harm. It's just what the provider perceives to be a potential for harm. Does not meet the standard of the law. Next, yeah. So Bridgewater providers also have to select what's called an indication for emergency medication order. And they are given 2 options. One is treatment of acute symptoms, and two is restraint to prevent harm. Now, treatment, as we discussed earlier, is not a valid legal basis for medication restraint, and this is a form for medication restraint. So it's an option that should not be present. Plus, treatment alone was the standard for the illegal emergency treatment orders, ETOs, that were already stricken from the policy a year ago. We looked at 13 restraints in a given week, a randomly selected week in the reporting period, to see how providers were approaching this section of the medication restraint form. And incredibly, on nearly half of the forms, 6 of the forms out of 13, the provider selected only treatment of acute symptoms, flying in the face of the law in this state. 6 of the forms used both options, treatment of acute symptoms and restraint to prevent harm. And only one form was filled out in any way that could be understood as in compliance with the law, with only restraint to prevent harm selected. It's a medication restraint form for medication restraint. That's the end of the story, or it should be. So this is just a remarkable and disturbing example of under DOC oversight, providers being enabled to flout Massachusetts law and continue to provide illegal medication restraints even after their policy was updated to be in compliance. The third concern, third section here, providers must describe what's referred to as a situation creating the risk and describe the risk if medication is not administered. So again, circumstances creating risk alone cannot justify medication restraint. The Massachusetts law says serious threat of extreme violence, personal injury, or attempted suicide. And by comparison, the DMH form for seclusion and restraint clearly calls for providers to describe behavior requiring emergency use and continuation of restraint and seclusion. Again, very different from Bridgewater. And it should be noted that Bridgewater psychiatrists ordering medication restraint often cite past circumstances from hours before, from days before, sometimes months before, about people's patterns of behavior to justify a medication restraint that is meant to be issued in the moment for a current emergency, just disregarding any lack of that current emergency. And finally, the section on least restrictive means attempted provides 8 options for staff to select, reflecting what alternatives were used before medication restraint, which, as KM discussed, should be the final option if needed. These include verbal de-escalation, taking space and time out, using a comfort room, being offered PRN or voluntary medication, etc. Many options are underutilized. Probably unsurprisingly, given Bridgewater's emphasis on medication, PRN medication is almost always checked. But as are taking space / time out and low stimulation setting, which are essentially euphemisms in the case of a prison, because that's basically referring to someone being secluded in their prison cell. So really not treatment. Verbal de-escalation is often marked, but from our observations, this can really just amount to staff telling someone to stop a behavior, not actually engaging them in a thoughtful clinical way. And these all just lead to concerns that medication restraint is not limited to use when it is the least restrictive, most appropriate alternative available. Thank you. So connected to that medication restraint form, what does medication restraint actually look like on the ground? What we see in monitoring, what we see in videos, what we see in notes and documentation of all kinds. So we have done over the course of the last period and most, every period, we had do dozens of interviews with patients at Bridgewater this past period. We viewed more than 30 videos of forced medication administration and reviewed restraint documentation and medical records. One, so this largest concern here that we're talking about in this section is around unjustified medication restraint because there are no emergency circumstances currently, which I think when going over the medication restraint form, we explained how that could very easily be. Um, Amazingly, despite the lack of emergency circumstances that we often see still, leading to medication restraint, Bridgewater providers almost never cancel an ordered medication restraint based on changing circumstances between the time it was ordered and the time it was administered. Out of 311 medication restraints that occurred over a 6-month period, and we'll go over these numbers more later, we found a single example of recovery solutions under DOC oversight discontinuing a medication restraint before administration, that they saw that the conditions had changed and that was sufficient to cancel the restraint. And they do not track these instances. So the types of scenarios that we have seen most frequently for medication restraint absent emergency are where an emergency circumstance was never present, where emergency circumstances no longer existed at the time of the restraint due to a delay in the administration, or 3, where the medication restraint was applied for a secondary purpose like a cell change, which we'll explain an example of that shortly. In each of these, there was a lack of requisite emergency circumstances and also Bridgewater's failure to explore less restrictive alternatives. So we have a number of examples here in terms of what these can look like. So these are using pseudonyms for patients at Bridgewater, and they are put together from observations that we made of video. In the first example, Alwyn was a young man who was secluded in his cell and spent over an hour in seclusion where he alternated between lying down, pacing, speaking with staff. An hour and 20 minutes later, a security staff came to his door. They spoke very briefly, and then in response, he got onto his bed and into a fetal position, lied down on his stomach with his hands behind his head, almost as if he were surrendering to police. And then four security staff in riot gear entered his cell and stood over him without laying hands on him at all. He complied, what they would call complied with the restraint, which was 3 intramuscular medication injections administered by a nurse. So in this case, there's both the behavior during the seclusion while he's in his cell, which clearly did not rise to the level of a serious threat of extreme violence, let alone an ability to affect any harm to anyone, and certainly no harm directed at himself. And then there's the fact that once staff came in so long later to administer this supposed emergency restraint, he fully complied with it, suggesting that, there was no violence, essentially. There was no resistance or anything that would comport with what the law suggested is necessary, or what you would expect in a case where it would be necessary. In the next example, this individual we call Barton, again a pseudonym, walked to his room without any force, any manual hold from staff. He was locked in his room. And after 20 minutes, he lied down on his bed and actually appeared to sleep for an entire hour. And then 4 security staff in riot gear entered with a nurse. And like in the previous example, he remained still, resting on his bed, almost appearing to sleep while the nurse administered 2 injections with the security staff standing over him. Again, it's hard to think of few more stark examples than one of somebody who was just lying in their bed being deemed to require a restraint from what. And then this last example here, this individual Carling, he was relaxing in his cell, talking with staff while he was on his bed. Um, I'll note that he had a puddle on his floor and some styrofoam containers from meals sitting there as well, which was noted in the notes that the reason they needed to move him out of his cell was because his cell was unhygienic, citing this puddle in the containers. Without laying any hands on him, they brought him to a clean cell across the hall. He was locked in that new cell, ate his lunch, sat, leaned against the wall in his stool for 30 minutes, looking very just relaxed and passing the time, occasionally speaking with staff through the window. And then staff instructed him to get on his bed, lie on his bed. And shortly after, they came in again, 4 security staff in riot gear, and stood over him while a nurse administered 3 injections. And to add insult to injury, when they brought him back to his original cell, they had left this puddle that staff appeared to be so concerned about in the notes in the middle of the floor. So it leaves one to wonder really what the justification here was. Another area that we've been looking at with regard to medication restraint, because medication restraint it can be done with oral medication, as we mentioned earlier. And in the new seclusion and restraint policy, it's actually explicitly stated that that is a preference, or that should be offered prior to escalating to intramuscular injection for a number of reasons, both avoiding staff and patient injury, and also avoiding trauma and basically harm reducing in these otherwise coercive and forced situations. However, so this basically is an opportunity to de-escalate, explore less restrictive alternatives. But what we see is that, like in many of the situations like the ones we just discussed, patients are often either not offered oral medication, are not informed that refusal of oral medication will result in intramuscular injections, or they're plainly denied oral medication if they ask staff. Particularly once staff, the security staff, are suited up for oral medication administration, and for lack of a better word, confrontation. So 7 patients that we spoke to specifically about this informed us that they received no oral medication offer prior to intramuscular injections. 4 of them said that this had occurred to them happened to them more than once. And 3 of these patients themselves reported that they asked for oral medications and were flatly denied. So it's a missed opportunity to try to make the instance of force a little less traumatic. Thank you.
Thank you, Jordan. This is Ariana. The use of medication restraint in illegal or otherwise unjustified and improper ways has been something that DLC has continued to track over our reporting periods, and it continues to be an ongoing problem at Bridgewater, even with the new policy changes that were implemented. Given that medication restraint is a serious intervention that should be used in very limited circumstances, it's something that we want to see reduced over time and something that we're trying to keep a close eye on. However, in our recent reporting period, medication restraints have been on the rise. We've reproduced some of the tables from our reports in our slides here to break this data down for you. So our reporting period lasted from mid-June of last year to mid-December of last year. So we were able to capture a full month of restraints for every month in this period, with the exceptions of June and December. It's also worth noting that this period reflects around when the new involuntary medication policy would have just taken effect. In total, we captured 182 days of this period. Over the months, you can see that in every period, there are more than one restraint for every day that takes place in the month, with the highest individual month of restraint being August of last year, where there were 63 medication restraints taking place over the 31 days in August. In total, staff gave 311 medication restraints during this period to 126 unique persons served. What that means when I say that is that a total of 126 Bridgewater patients were given medication restraints. And since the number of actual medication restraint taking place is higher than that amount of people, it's likely that many of these patients were given a medication restraint more than once over the course of this about, half of the year period. On average, there were 1.71 medication restraints taking place at Bridgewater per day. This is an increase compared to the average of 1.37 medication restraints per day from our last reporting period, which took place between mid-December to mid-May of 2024, and an increase compared to the period before that, which took place from mid-June of 2023 to mid-December of 2023. Based on these rates, Bridgewater's overall rate of medication restraint went up by 25% during this reporting period shortly after that policy change, and is up by 36% compared to only a year prior. If you were here for our overview webinar on Bridgewater last week, you probably remember that we pointed out that Bridgewater also chronically overrepresents Black and African American folks in comparison to the overall population in Massachusetts. But we wanted to review that here as well, given that this pattern of overrepresentation is something that is also seen in medication restraints. So if the representation of individuals in Bridgewater by race was proportionate, we would expect to see percentages of groups by race be relatively similar when looking at the Massachusetts population and then looking at the Bridgewater population. In reality, Black or African American individuals comprise only 9.6% of the overall Massachusetts population. But when you look at Bridgewater specifically, that number jumps, and Black or African American individuals end up making up 39% of the population. Given that Bridgewater does not track if individuals are white but not Hispanic or Latino, we can't be completely sure if the 11% of Hispanic or Latino individuals at Bridgewater is entirely accurate. But the way that DOC and Bridgewater report this data is expected to change by the next reporting period, so we may be able to get some more accurate numbers there in the future. Black and African American patients continue to be overrepresented in medication restraint administration at Bridgewater. Black and African American patients received 55% of all of the administrations of involuntary medication restraints in this period, and represented half of the unique patients receiving medication restraints during this reporting period. Again, despite only comprising 39% of the Bridgewater population. This isn't the first time that we've seen these kinds of numbers. During the last reporting period, Black and African American patients with 34% of the Bridgewater population received 41% of administrations and made up 42% of unique patients receiving medication restraints. That's compared to this period where white individuals made up 44% of the Bridgewater population, but received 39% of medication restraint administrations at Bridgewater. And white patients made up 42% of the unique patients that received medication restraints during this reporting period. The current period's numbers represent a nearly 128% increase in the percentage overrepresentation of Black and African American patients receiving medication restraints, and a 38% increase in the percentage overrepresentation of unique Black and African American patients that receive medication restraints. These numbers are troubling and demonstrate that the contracted provider, under DOC's oversight, continues to utilize practices that disproportionately impact patients of color who are already overrepresented at Bridgewater, even when comparing to other DOC facilities. It's also worth noting here that because of how DOC has been reporting their race and ethnicity data, that DLC was unable to pinpoint the total number of Hispanic or Latinx patients who received medication restraint, because the reporting did not allow for patients to identify as a person with Hispanic or Latinx heritage and by their primary race. When controlling for primary language, however, 5% of all medication restraint administrations were given to patients whose primary language is Spanish. These restraints were administered to 10 unique patients, representing 8% of all patients during this period that received a medication restraint. 7 of these individuals were categorized by race as white, 2 were categorized as Black or African American, and 1 was categorized as unknown. So near the end of last year, DOC began reporting Hispanic or Latino or not Hispanic or Latino status in providing data to DLC. And going forward, we plan to report on medication restraint administration data using the updated demographic information that DOC provides.
Thank you, Ariana. This is Tatum. So we're back to irreversible deterioration orders and how they take place at Bridgewater. The title of the slide, as reflected in the title of our report from February 2025, is improper irreversible deterioration orders, indicating that there is cause for concern in current practices. DLC noted an increase in the use of IDOs during the last reporting period. There were 9 unique patients subject to IDOs. While that doesn't sound like a lot, it is a marked increase. And keep in mind that this is an intervention authorized only in rare circumstances to prevent immediate, substantial, and irreversible deterioration. All of the 9 IDOs that were issued were extended orders. Those orders ranged from 18 days to 108 days, meaning a standing order for involuntary medication. That is not in keeping with the spirit or the letter of Massachusetts law that permits this exception with respect to involuntary medication of individuals. Keeping in mind, there are the 3. You have a court-ordered treatment plan. There are emergency circumstances such that a chemical restraint or medication restraint is warranted, or there are the circumstances justifying the IDO. So what we have here is Bridgewater allowing for extended orders. Recovery Solutions did not track the total number of forced medication administrations in the name or within these IDOs on those 9 different patients. So with that in mind, the person who had the IDO that lasted 100 days may have received involuntary medication under that order 108 times, or as you'll see in the upcoming example, twice a day. So double that, 216 times. But the contracted provider does not track that, and DOC does not require them to. We do understand from the contracted provider, specifically from the medical executive director, that 2 to 4 patients approximately receive IDOs on any given day, thus substantiating DLC's concerns that although there are a limited number of orders, they are the basis of a large number of untracked involuntary medication administrations. The only way to find out when these are taking place, the only reliable way would be through a review of every single person's served records in the hospital or in the prison. DLC is not able to conduct such a review, and thus we are devising ways to try to get that information in a clear and reliable way. As already touched on, many of these or all of these IDOs were inconsistent with Massachusetts law, whether because of the lack of the rare circumstances the law requires, or simply because they are extended orders. Be aware that no court order is required for a single IDO. But if doctors expect to continue to treat the patient with forced antipsychotic medications, they must seek a Rogers order or a court-ordered treatment plan. Examples that we have reviewed indicate that irreversible deterioration determinations are not grounded in limited observations, selectively or vaguely described behaviors, and behaviors that could be attributed to purposeful non-compliance, meaning patients refusing to cooperate. And as a result, DLC is concerned that in some situations where patients are deliberately non-compliant or not cooperating with providers or intake procedures, they are being subjected to punishment by means of involuntary medication through IDOs. Given the medical executive director's past practices and regular commentary criticizing the legal requirements limiting psychiatrist discretion to medicate people without their consent, DLC, frankly, is not incredibly surprised by the indications of these IDO practices. Recovery Solutions, as DOC's contractor, has taken great liberties in interpreting the language of both the new 2024 policy and the law to formulate its quote-unquote IDO protocol. The protocol places the responsibility for authorizing these orders on the medical executive director or a designee, after consultation with the patient's treating provider. The protocol specifically states, as stated here on the slide, that it is meant for patients who require sustained treatment to alleviate symptoms resulting in risk of irreversible deterioration while they are awaiting a court hearing to determine competence and treatment. The protocol states that it can only be initiated if the patient's provider has submitted paperwork to seek a Rogers order. And the medical executive director, as I said, conducts a clinical review. According to the protocol, if approved, patients are informed that they will not be permitted to refuse their medication. Now, this alone, but really all of these components are incredibly concerning, keeping in mind what we've already discussed and the words of our Supreme Judicial Court in laying out this limited exception and discussing the limitations of court-ordered treatment plans. The court stated that there are few legitimate medical procedures which are more intrusive than the forcible injection of antipsychotic medication. It also made clear and acknowledged there's a conflict between the interest of a hospital administrator or provider and the right to choose and consent to treatment of patients. Doctors who are attempting to treat and maintain, as well as maintain order in the hospital, according to the SJC, have interest in conflict with those of their patients who may wish to avoid medication. This is really important to keep in mind, especially given what we just discussed regarding our observations and concerns about the use of IDOs. Without meeting the proper legal standards, this is another mechanism for Bridgewater, similar to ETOs, to administer medication at will, at the discretion of the psychiatrist, without having to meet the clear requirements of the law for each administration. The patient's status on the IDO protocol is tracked only in treatment rounds, and the patient, per the protocol, is seen at least weekly by their psychiatrist. Now, this is also incredibly concerning, again, because IDOs are meant to be limited one-time treatments or treatments based on an immediate determination that they are at risk of immediate, substantial, and irreversible deterioration. Thus, a long-term order that only requires rounds and a weekly visit from a psychiatrist is at odds with the notion that this is an immediate assessed need to prevent the worst case scenario. So we do have an example, a very striking example that we included in our report of a long-term IDO on a patient who we called Damon. At admission, Bridgewater staff described Damon as appearing catatonic and calm, but refused to talk. As a result, Bridgewater staff couldn't complete the intake process. Staff then put Damon in a dry cell. A dry cell at Bridgewater State Hospital, and frankly at other jails and prisons, means a cell with no running water, meaning generally no toilet or sink, so not a standard cell. They then ordered an IDO immediately by intramuscular injection. Throughout Damon's almost 50-day stay at the facility, so keep in mind that was as soon as he arrived. Within hours of his arrival, he was assessed to be at risk of immediate, substantial, and irreversible deterioration despite the provider's very limited exposure to him and his mental health history. For 50 days thereafter, he was forced every day to take lorazepam tablets twice a day, or if he refused those tablets, intramuscular injections twice a day, per the extended IDO. All of these forced medications were based on an assessment and justification for the IDO of catatonia. despite evidence that contradicted that he was catatonic. Damon described to DLC speaking with Bridgewater staff, and his medical records substantiate that this occurred, documenting numerous instances of him verbally communicating with staff. Damon repeatedly stated to DLC that he was taking the oral medication with a gun to my head, because he was afraid of getting more intramuscular injections. He described that the medication often made him feel hungry and sick. Note also the fact that Damon was able to convey all of this quite clearly to DLC, showing that he was verbally able to communicate his needs and most certainly capable of discussing his treatment options, indicating that he did not meet the standard or the standard for an IDO, but also the clinical indications of catatonia. In fact, Damon conveyed to DLC that he was completely aware of what was going on at admission. He simply didn't want to participate. Damon was consistently and incorrectly told, while all of these forced medications were being administered, that it was court-ordered medication. And medical records also inaccurately reflected that he was receiving court-ordered medication, indicating not only an incorrect understanding by staff, but the fact that the patient was being informed of things that were clearly inaccurate about his treatment and inaccurate about the legality of his treatment. Note also that Bridgewater did not petition for court-ordered medication until 15 days after Damon arrived, meaning 15 days after he began receiving forced medication pursuant to the extended IDO. Now, even by the protocol established by DOC's contractor, this is non-compliant. The protocol specifically states that an IDO can only be initiated if the provider submits paperwork for adjudication of incapacity and a treatment plan. Similarly, the Supreme Judicial Court has made clear that you have to petition if you plan to, based on the irreversible deterioration issue, if you plan to force medicate to prevent irreversible deterioration, after that first time, you must seek a court-ordered treatment plan. Bridgewater did not do that for 15 days and subjected Damon to that forced medication throughout that period of time. So this is just another stark and concerning example of issues, both new and old, with forced medication that DLC continues to observe and document.
Thank you. This is Jordan. Now we'll discuss the use of violence and restraint and involuntary medication administration at Bridgewater. Bridgewater staff under DOC oversight regularly use undue force on patients. Their practices look like prison planned uses of force. As we mentioned earlier, teams of usually 4 security staff wear tactical gear, including helmets with plastic visors over their faces, elbow pads, knee pads, jumpsuits, and plexiglass riot shields sometimes that they use to enter a patient's cell and essentially bash them or push them onto their bed to gain compliance. These altercations can frankly look like street fights due to the lack of training and just the uh, horrible circumstances that uh, staff decide to put everyone in when they choose to force medicate someone in a small cell who's usually not posing an immediate threat. Um, so these practices negatively impact staff culture. They negatively impact patient mental health and sense of safety. There are physical and emotional injuries for patients. And for others who see or hear these interventions go on um, from their cells while they're locked in on the whole unit because there is a what's called a planned event going on in one cell, staff in riot gear going on and going in and force medicating someone. So, just for some context, there were 619 planned events during this 6 month reporting period. Those planned events include security staff, as I mentioned, going into patient cells for both medication restraints, as we've discussed extensively, but also for court-ordered medication if someone refuses to take oral medication or staff deem that they need to be manually held down and administered court-ordered intramuscular medication. In 219 of those events, staff were wearing riot gear or protective gear. And in 9 of those events, they were using a shield, which are some of the most disturbing videos to see in our review. So, next slide, please. This is a quote from a patient at Bridgewater who we had discussed a restraint, physical or manual restraint, and a medication restraint that he had recently received. It says, the patient said, "To be honest, it's terrifying, especially if you're not from a world with all that violence. Saying it's horrifying is an understatement." That's one of many quotes that we hear from people describing these experiences. So we're going to provide an example here of a description of video that actually included sound. Some of our video, the security, stationary security camera video does not include sound, but handheld video, it does include sound, which DOC has begun using during planned events and forced medication, intended as another form of accountability. And what it shows with the sound is really just another layer of how disturbing these are. In this case, there was an individual who we're calling Eli, who was in his cell standing in front of the door, and 4 security staff in riot gear run in. Eli's a very small young guy, early 20s, and a very large security staff tackles him. So he's face down on his bed. Security staff put their body weight on Eli's torso and legs. They contort his right arm behind his back while he's lying on his belly, ultimately pinning that right hand to his right shoulder blade. And he is wailing in pain and saying, my arm, please no." Nurses at that point come in and give him an intramuscular injection in his buttocks. And while he continues to intermittently scream and whimper and pant, and they leave the cell, staff leaves the cell and slams the door, leaving Eli on his bed. And nobody during the entire time interrupts the process to ask him where it hurts or assess if he has any injuries. They're just getting done the forced medication. So it's, these are really disturbing videos to watch. I mean, I think the way the individuals are handled during the process, the altercation, you could call it, is one thing. And then really that moment when staff leaves the room and leaves the patients on their bed, sometimes with their pants down around their ankles or their knees because it's been pulled down by staff. Sometimes there is a bloody mark on their buttocks from where they've been injected because different people respond differently. It's done differently by different nurses. But just that moment of shock and of what just happened and why is really horrifying to witness. So yeah, that's an example of what happens not infrequently. And I think, Ariana, let's skip this slide and go to the next one, just in the interest of time. Thanks.
Thank you, Jordan. This is Ariana. So to finish up our discussion of the restraint and care and treatment issues there, I am going to talk about undocumented and authorized seclusion issues that DLC has continued to report on. So because Bridgewater is a DOC facility, patients at Bridgewater will spend extended periods of time locked in their cell daily, comparable to other county correctional facilities and prisons. At minimum, every patient is locked in their cell daily from 9:20 p.m. to 7:20 a.m. This takes place regardless of behavior, treatment compliance, commitment status, or any form of individualized assessment on the impact of isolation in a prison cell on a patient's mental health. When accounting for this overnight lock-in alone, in a year, patients at Bridgewater spend a combined time of over 900,000 hours secluded in their cells, before counting any other situations where Bridgewater would seclude them. Again, like a DOC facility, patients at Bridgewater have to participate in facility count that takes place 3 times every day. During the recent reporting period, the contracted provider began offering the option for patients to stay in the day room for midday and afternoon count, but they're still required to do so at another count during the day. Overnight lock-in and count lock-in hours are excluded from the definition of seclusion in Bridgewater's policy. But in a legitimate psychiatric hospital in the state that would be governed by DMH, all seclusion must be documented and ordered based on a finding of emergency circumstances warranting the seclusion. But as I've suggested here, this just describes the minimum scenarios where Bridgewater secludes patients. Additional unauthorized seclusion takes place outside of these times throughout the day, especially in the Bradford unit, which houses new admissions, and the maximum security units of Hadley and Lenox. Even Bridgewater's contracted provider, Recovery Solutions, recognizes that even brief periods of time being locked in a room can have deleterious mental health consequences. Seclusion is known to exacerbate symptoms, correlate with development of post-traumatic symptoms, feelings of punishment and distress, and can even increase the length of time that a patient is in a hospital. Patients at Bridgewater have described seclusion to be mind-numbing, anxiety-provoking, and traumatic to experience, and have told DLC that it can feel like being in solitary confinement at a prison. This slide here depicts an older photo of the average cell at Bridgewater. We showed it at our first webinar. Again, if you were to see it now, the size and features of a small bed and the toilet and sink apparatus would be the same, but you would likely see a lot more wear and tear with graffiti on the walls and cracks in parts of the flooring that have chipped away. This is often where an unauthorized seclusion is going to take place. Because these seclusions often go undocumented, Bridgewater records omit mention of this additional seclusion time. DLC has and will continue to request that Bridgewater develops a process for post-seclusion documentation. We continue, though, to hear reports from patients there about how staff are secluding them. On Bradford specifically, a patient who had been on the unit for 16 days reported to DLC that he had been locked in his cell for lengthy periods of time, that on 2 days, staff did not release him until later in the afternoon, and that on 1 day he was not allowed out of his cell at all. Another patient reported that he was only allowed out of his cell between 2 to 4 hours a day while he was on Bradford. For Bridgewater generally, a patient reported that he'd been locked in his cell for an entire day twice, and on other days he had only received half an hour of time out of his cell for recreation. In addition, both patients and unit staff informed us that patients were routinely kept in seclusion during lunch due to being unit restricted. DLC has reached out to Bridgewater administration multiple times about seclusion issues. The contracted provider has responded that these kinds of seclusions were not accepted practice and that a reminder was sent out to all units to this effect, but we still hear reports from patients that these seclusions keep happening. I also wanted to provide an outside view of the kind of cells that are just pictured. You can see here how close the cells are together. You can also see a little bit below the number on the door, these metal wickets that can be opened to hand food to patients if they're in their cells. From ongoing monitoring, DLC has observed that these can be a point of contention between staff, with staff shoving things into the wicket, opening harshly, or patients having to stick their arms through the wickets to attempt to get the attention of staff. Overall, patients have told DLC that once they're locked in, it's incredibly difficult to get staff's attention. They may be forced to knock loudly on the inside of their doors or scream to get staff to pay attention. And these actions can then put them at risk of being force medicated while they're already in seclusion if staff perceive these behaviors as agitated or violent. And to finish up, I'm going to pass things over to Tatum to talk a little bit more about contract reform and issues with the OCCC Annex units.
Thank you, Ariana. This is Tatum. So we discussed in the last session the need for reform as the new 2025 contract begins on July 1st. At the time we issued our last report on February 6th, the contract was still open. We now know that DOC has already awarded Recovery Solutions, formerly WellPath, the contract. As I said, these services will begin in July 2025, a continuation now of this provider since 2017. We emphasized at the time we issued our report very important considerations and changes that any provider taking on the new contract should and really must adhere to in order to protect the people who currently reside and who will in the future reside at Bridgewater State Hospital. These are essential from our perspective, given our observations of the last decade. First, new leadership is necessary at Bridgewater State Hospital. When we talk about new leadership, it encompasses a lot of different positions, but one of those emphasized particularly in the report is a new medical executive director. The current medical executive director has been at Bridgewater State Hospital for a very long time. He has had a leadership role not only in the facility at large, but also had a leadership role in the intensive treatment unit, or ITU, discussed earlier, which was the site of countless hours of illegal seclusion and restraint activity, and gave rise to the two settlement agreements discussed in 2014, of which DLC was a monitor. This is incredibly concerning, not only because professionals who took part in those illegal practices are still at Bridgewater and in leadership roles. But it's also concerning because those leaders, those individuals in leadership positions also have a level of comfort with those practices and the other practices that took place while corrections officers were inside the facility. The need for reform after those settlement agreements was obvious. Unfortunately, the reform did not carry over into those clinical leadership positions. So, from DLC's perspective, in order to achieve significant, meaningful change that is necessary at Bridgewater, even while it remains legally under the authority of the Department of Correction, something must be done. A changing of the guard is in order to bring in individual providers and hospital administrators who have extensive experience in running hospitals, not prisons masquerading as hospitals. In addition to the change in leadership, DLC emphasized the need to improve staff credentialing requirements for psychiatrists and medical doctors at Bridgewater. Looking through the Massachusetts Board of Registration in Medicine, DLC was able to identify 5 physicians at Bridgewater State Hospital, 2 of whom who hold leadership positions who have no reported board certifications. While not a requirement to practice medicine, it is widely regarded, particularly in the medical community, as essential. The function of a board certification is to show specialty, but also to show a continuing engagement and awareness of current practices and standards of care. So this was one of the key enhancements that we wanted to see in the new contract and in DOC's original requests for responses as part of that contract to eliminate those the opportunity for physicians who are not board certified to serve some of the most vulnerable individuals in our state from a psychiatric need perspective, and to be able to provide a high level of care for this population. We also look, as we must, in monitoring Bridgewater State Hospital at the treatment and conditions in the Old Colony Correctional Center, Bridgewater State Hospital Annex units. These units were created after the introduction or the removal, rather, of corrections officers from Bridgewater State Hospital proper. State sentenced in prisoners or individuals sentenced to state prison sentences were moved to Old Colony, to the Intensive Observation and Stabilization Unit, or to the residential unit. The ISOU, as it is commonly known, is the Evaluation and Observation Unit to determine whether someone warrants commitment, and the residential unit is where individuals who are committed, who are sentenced state prisoners, where they go for their continuing care. We have consistently heard complaints from individuals in those annex units, and through documentation and monitoring visits have observed differences in groups and access to clinicians in available to patients in the ISOU versus the residential unit. meaning the ISOU has very limited access to groups and access to clinicians and other programming options. This is cause for concern, given that it is the observation and evaluation unit. It is generally where individuals who have come from either other parts of Old Colony Correctional Centers or state prisons from across the state who are in mental health crisis and may have engaged in serious self-harm or a suicide attempt end up. So DLC and those who are committed for evaluation and observation in the ISOU would really like to see more robust access to providers and to treatment and programming in the ISOU. It there are minimal groups offered in the ISOU, as I just said, despite a large number of staff, particularly corrections officers. Roughly 5 corrections officers sit in the unit that has a capacity of 18 patients in it. So this creates an environment that can be seen as highly correctional and also very intimidating. ISOU patients describe the unit as torturous, boring, and not therapeutic. Patients commonly report that certain ISOU officers may be verbally and physically abusive in their day-to-day interactions. DOC practices for officer assignments in these units have shifted drastically since the units opened in 2017. At that time, DLC observed that DOC specially chose officers interested in working on those units and officers who had special skills in working with patients with mental health issues being assigned. Since then, the practices have changed, and now it's simply assignments to those units operate as if they are any other units. The individuals assigned there, the officers that is, do not receive special or more intensive training than other corrections officers. And as a result, the outcomes for patients on those units have differed depending on the performance, aptitude, and treatment of those officers. We have recommended in our report that DOC needs to commit to either using contracted provider security staff that work together with the contracted providers therapeutic staff in those units, or to ensure that the collective bargaining agreement that dictates how assignments are made permits selection of officers suitable and adept at working with individuals with significant mental health needs. Occurs. Next slide, please. So now we're at the stage of the presentation where it is time for questions. We unfortunately only have about 17 minutes, and I see that there are a great number of them in the Q&A, so we can get moving. Ariana, if you'd like to call any to attention as we go through to try to be efficient, that would be great.
Yeah, let me take a look at these. Okay. We'll start with we have a question from Harry that mentions that given that the DOC commissioner continues to allow illegal practices, why isn't he being held accountable and why haven't we seen change? And also asks what more advocacy groups can do to end these violations.
Uh, I think, we certainly have seen changes within Bridgewater, but not enough. In terms of why haven't we seen change in terms with respect to the agency overseeing Bridgewater? I wish I could say why. It's certainly not due to a lack of documented issues with the current arrangements. Um, what we have in Massachusetts, the issue is that state law puts Bridgewater State Hospital under the authority of the Department of Correction. So in order to change it, there must be a legislative action. So if that is the aim of advocacy, to transfer Bridgewater to the Department of Mental Health, then the advocacy needs to be focused on the legislature to ensure that bills moving forward that would affect that change pass.
Yeah. Okay. We also have a question that says, it doesn't seem like the accreditation process examines these issues. Ultimately, is there any overseeing body that can hold DOC accountable for non-compliance or flagrant disregard for policies?
So it's important to keep in mind that Bridgewater State Hospital is accredited as a prison, and it's also accredited as a behavioral health provider. It is not accredited as a psychiatric hospital. So the accreditation requirements by the Joint Commission are not those that we would see in terms of a Joint Commission accreditation of an actual psychiatric hospital. The other issue with accreditation is that it's unclear whether accreditation looks squarely at the requirements of state law. So is there an overseeing body that could hold DOC accountable for non-compliance? Well, our state government could, and the court system could, and the legislature could by making the change that we discussed.
Another question we received is asking, what does Governor Healy have to say about the violations that DLC mentioned here, and asks if we've met with her directly on this issue?
We have not received direct responses from the governor on this issue. We receive responses generally to our reports. Though they are sent to a number of government officials, we receive the responses from the Commissioner of the Department of Correction.
And an additional question that we had was asking how the IDO protocols between Bridgewater and DMH compare.
There's no such, to my knowledge, DMH doesn't use any term IDO protocol. It would just be an irreversible deterioration order. The DMH regulations follow the letter of the law and when those are permitted, and the use of IDOs in DMH are incredibly limited and in keeping with what one would expect given the limitations set by the law.
Okay. And let me see. I have a couple of additional questions, asking why there hasn't been any legal action taken against Bridgewater since 2007, if there is a related plan to take action. And I believe this is related to that question of who individuals in the audience should be reporting concerns to, if they feel the need to report this alarming information.
I'm a little unclear what the legal action referenced in 2007 is. The the Minnick litigation settled in 2014, and there was an ongoing monitoring. That was a class action lawsuit. So I'm not entirely sure what that is referring. Um, you know, all options are on the table in terms of how to address issues. The 2024 policy changes address very clear legal issues and consistent legal violations in the form of those emergency treatment orders. So that was a significant legal victory, even outside of a courtroom. So changes do continue to be made. I just think, the progress is slower than any of us would like to see. And, obviously DLC does not believe that Bridgewater should be within the control of the DOC. And we also believe that patients should be in an appropriate hospital rather than a prison. And I'm not really sure I understand to whom loved ones or interested parties should report these issues to. Uh, if I follow up on what I said earlier, in that the law must change if authority is to be transferred to DMH, then I suppose who you should report it to would be your state legislator. Sorry, I'm reading through them.
We did also have a question. We may have already addressed this a little bit before, of what DLC is currently doing to address these issues, and if we plan on taking any other legal actions, i.e., suing the Department of Corrections on behalf of patients.
That's not something we're going to discuss in this webinar. So I see a lot of questions that are directed at people being unmedicated, and there was a question related to untreated psychosis being dangerous, and concerns about people decompensating, and asking what will DLC do to ensure that people are medicated. Well, first, this is a webinar about Bridgewater State Hospital. So it's not really the forum for discussing broad advocacy issues around forced medication. But I can say that as the Protection and Advocacy Agency, it is DLC's role and mandate to protect and advocate for the rights and interests of people with disabilities. So as discussed, forced medication is an extreme measure that implicates individual rights. Even people involuntarily committed to psychiatric hospitals have the right to refuse and consent to treatment unless they fit within those three limited circumstances that we discussed. So DLC will always stand for the rights of individuals with disabilities to have their rights respected.
We did have another question, Tatum, if asking if we could speak to the prospects for transferring Bridgewater to DMH.
Um, in terms of, I'm not sure prospects, like the likelihood or how it would work. Is there more specific information in the question, Ariana?
No, but I think that maybe considering like the transfer legislation to Bridgewater might be relevant.
Well, so there is a bill pending or two bills pending at the legislature that would transfer Bridgewater from the DOC to DMH. Those bills went through several rounds and got as far as they have ever gotten in the last legislative session with enough support. Our hope is that they might be able to pass this session. At the same time, there is a study being conducted um, of um, of a potential hospital to serve the Bridgewater State Hospital population. The Department of Mental Health has sponsored that study. And I don't have any recent updates about the progress of that study, but it is underway. So DLC deeply hopes that the prospects for the eventual transfer to the Department of Mental Health are good. We work hard. Jordan works very hard day in and day out to ensure that we know what's happening at Bridgewater, that we are advocating for the individual interests of patients on the ground, and that we are advocating systemically about wide-ranging issues or significant problems that we are seeing that are affecting the care, treatment, and environment in which patients at Bridgewater have to live. So, I'm holding out hope that it's possible. But I can't put any qualifier on how likely it is. I think that a lot of that depends on the momentum that the change has and the advocacy from the community supporting that change. So I'm seeing language in the questions about uh that suggest, how well, I'll go to the last one. Donna says, could we get your first recommendation for DMH to take charge in place since a new facility will take time to come to fruition? Donna, that is exactly what we mean by our recommendations. We feel that the transfer to DMH should immediately take place. We understand that there will be significant challenges in taking over care at Bridgewater State Hospital. It's an environment that DMH doesn't currently operate in, a prison. But we do feel that the application of DMH policies and regulations and practices will be an incredible change that protects the health and safety and rights of patients at Bridgewater. So we do feel that that should happen without delay. And you know, we feel that it needs to happen certainly before any new hospital can be built. That said, the hospital itself is essential, and we'll be discussing that in our third and final installment of these webinars. The fact that the Bridgewater physical plant is really in incredible disrepair and includes environmental contaminants and other serious conditions issues that negatively impact the health of patients, such that it really needs to be out of use. You know, not just today, but years ago. Well, it's 3 o'clock, and I apologize for any questions we weren't able to reach. But our email addresses are available on this last slide. You can also contact us through our DLC website, and also mail@dlc-ma.org should you have any questions that you would like us to address in writing, or to, if time permitting, set up a call to discuss your concerns. So thank you very much again, and I apologize for running out of time. Ariana and Jordan, any final words?
Thank you all for joining. Appreciate your interest and advocacy.
Yeah, thank you all so much for coming.
Thank you.